Case Law School, we believe, has one of the most vibrant lecture series of any law school, and today, and this lecture, is typical of what we do, and it adds much to the intellectual life of our school. This lecture is part of a growing international human rights and global justice program which we put on here at the school, and it had its genesis in a generous endowment gift which we received about 8 years ago from a Case alumnus named Bruce Klatsky, and we are grateful to him for having stimulated what we are doing here and what Michael Scharf and the Cox Center do all year long. The Cox Humanitarian Award, which we'll be giving out today, is sometimes called Cleveland's Nobel and is given every year to honor an individual who has made a significant contribution to advancing global justice. The achievements of the recipients of this award speak for themselves and merit our recognition of them as we do on an annual basis. But we should also understand, and we do appreciate, that the presence of the recipients of the awards, as is the case with Judge Pillay, really graces both our law school and our city. So it's a nice combination of recognition of them and their recognition of what we do here. Past award recipients have included Hans Corell, the UN Undersecretary General for Legal Affairs, Philippe Kirsch, the President of the International Criminal Court, Tom Buergenthal, the U.S. Judge on the International Court of Justice, Luis Moreno-Ocampo, the Chief Prosecutor of the International Criminal Court, and Robert Petit, the Chief Prosecutor of the Cambodia Genocide Tribunal. We are also proud at the law school, all of us, about the contributions that our faculty and students involved in the work of the Cox Center have themselves made to the general dialogue and conversation about global justice through their publications, by organizing symposia and expert meetings, and by providing research assistance to 5 international tribunals. I also want to take this opportunity to alert you to the next opportunity for joining with us in these pursuits. Our next major international conference, titled After Guantanamo, The Way Forward, will be held here on September 11th, an appropriate date for having such a session. This unique conference consists of 4 roundtable discussions featuring leading experts on the questions of what to do with the detainees if the Guantanamo facility is closed down, whether to prosecute terrorists in federal court or revamped military commissions, and how far up the chain the new special prosecutor should go with his investigation into the acts of torture committed by CIA interrogators, or allegedly so. So, it promises to be a timely and very exciting day, and we hope you'll be able to join us for that occasion. It's now my pleasure to turn the program over to Shannon French, the director of the Inamori International Center for Ethics and Excellence, a co-sponsor of today's event, who will introduce the judge. Shannon.
Thank you, Bob. Before I begin, I would just like to say thank you to Dean Rawson and most especially to Professor Scharf for creating these exciting events. The Cox Center is indeed doing a great deal to encourage these conversations among us, and I hope you will be able to join them for the events on September 11th, which will continue the conversation. It's my pleasure to introduce this year's recipient of the Cox Humanitarian Award for Advancing Global Justice, Judge Navi Pillay. Judge Pillay has had a number of firsts. In 1967, she became the first woman to start a law practice in South Africa's Natal province, providing legal defense for opponents of apartheid. In 1995, she was the first non-white woman to be appointed to the High Court of South Africa. She was the first woman to serve as the president of an international tribunal when she was elected the president of the International Criminal Court. In 2003, she became one of the first judges elected to the International Criminal Court. She was elected in 1999 president of the Rwanda Tribunal. And in 2008, she became the first African to be appointed UN High Commissioner for Human Rights. With a $120 million budget and a staff of 1,000, the High Commissioner coordinates human rights activities throughout the UN system and supervises the Human Rights Council in Geneva. Judge Pillay has said that the High Commissioner is, and I'll quote you here, the voice of the victim everywhere. She has devoted her life to promoting human rights and global justice. Today, she will share with us her views on women's rights in the human rights system, past, present, and future. We will have her speak for about 40 minutes and then open up for about 15 minutes of Q&A to engage with you. So please join me in welcoming Judge Pillay.
Thank you, Dean Rawson and Shannon, for the kind remarks. Above all, I want to say how pleased I am to be here and also to see so many students. I get very anxious about addressing or delivering a lecture at campuses because you never know whether the students are going to turn up or not. I once had the misfortune of going to deliver a lecture at the university in Durban, and there were just 4 students there. So therefore, I'm just so pleased, term having just started, that you are here. I'm very, very honored to receive this award from the Frederick Cox International Law Center, and of course co-sponsored by the Imori Ethics and Center for Ethics and Excellence. And actually, I got this call from Professor Michael Scharf when I was still a judge on the International Criminal Court. I don't know if he had some idea that I would soon be resigning from that court because all the member states elected me High Commissioner for Human Rights. And so therefore, I don't use the judge title any longer. I'm just plain HC now. That's how they address me. But I understand that once you're a judge, you keep that title. So as I said, I'm very pleased to be here, and also I do appreciate, Michael, that you accommodated me to the extent you did in arranging this date. It really, you could see how long it took us to get a date here. So I thought then I will deliver this lecture on women's rights in the human rights system, but focus particularly from the point of view of victims, since I'm now the High Commissioner. And of course, I'm very thankful for your invitation to, which allows me to deliver this lecture in the context of global legal reform. And so I've entitled my lecture, Sexual Violence, Standing by the Victim. And as I said today, I speak as High Commissioner for Human Rights and also as a committed and long-time advocate for women's rights and gender equality. And as such, someone who believes that today's discussion is essential. Moreover, as former president of the International Criminal Tribunal for Rwanda and judge on the International Criminal Court, I also warmly welcome your debate. At the outset, let me say that I was heartened by the progress made so far regarding the prosecution of sexual violence. The jurisprudence and methodology developed by international justice systems, as well as national tribunals or regional courts, has made great strides. Yet we are still wanting in our capacity to fully describe, understand, and address the real experience of sexual violence from the victim's perspective. My office, the Office of the High Commissioner for Human Rights, OHCHR, has closely studied whether the programs, policies, and normative architecture which form the basis of the work of the international community in a post-conflict setting provide adequate access to justice for women seeking it. From this perspective, my office, jointly with the non-governmental organization Medisa Mondial, organized a conference entitled Seeking Justice last year. And our purpose was to gather a variety of views and experiences on the topic of sexual violence and justice. This event was attended by women from 26 countries, the majority of which had recently been in conflict. Many among the participants had themselves experienced such violence and had sought to end impunity through formal justice mechanisms. Their purpose had been to ensure that sexual violence be prosecuted and perpetrators held accountable. So 3 fundamental questions emerged from that conference, and they are: 1, whether the law has actually succeeded in describing women's experience of violence; 2, whether the ways in which sexual violence is investigated assist in the understanding of that experience from a woman's perspective; and thirdly, whether in fact our current practices actively discriminate in the delivery of justice. So against this background, I will outline for your consideration some thoughts on the normative framework that anchors the prosecution of sexual violence. I will then briefly examine how the legal architecture at our disposal can contribute to more effective investigations. And finally, I will discuss how we can draw from methodologies of other legal processes to bolster the ability of international criminal justice mechanisms to prosecute sexual violence. Let me reiterate that from today's vantage point, considerable progress has been made from the time when violence and related offenses against women were merely seen as crimes of honor. Indeed, there has been a quantum leap forward in the prosecution of sexual violence before international tribunals. The jurisprudence of these courts represented a watershed for women whose wartime suffering had long been considered as an inevitable byproduct of conflict or as collateral damage that could be more easily tolerated and consequently disregarded. Through the work of international courts, we have been able to establish once and for all that where threshold criteria are met, rape during international or internal armed conflict is a war crime, a crime against humanity, and may constitute an element of genocide. It is a crime often planned and systematically perpetrated that must be explicitly prosecuted as such. I will leave to others to revisit the evolution of rape as a crime under international law. It is, however, important to highlight here the inclusion of an explicit reference to rape in the statutes of the ad hoc tribunals for former Yugoslavia and Rwanda, the post-conflict special courts, and the International Criminal Court. Subsequent judicial interpretations of the ad hoc tribunals, as well as explanatory paragraphs from the ICC, proscribe sexual violence. The normative framework, therefore, is in place. However, if we take even a cursory look at the extent of the prosecution of sexual violence perpetrated during conflicts, it is clear that we are only addressing the tip of the iceberg in terms of cases examined and merely scratching the surface in terms of our understanding of how women experience violence. Now for the issue of consent and the trauma of description. The experience of law that remains in the minds of women is how they are treated in the courtroom, as it is there that justice is expected to be delivered. Stemming from actual cases heard in court, some questions have emerged consistently. These questions revolve around the dilemmas of whether, in their interaction with formal justice mechanisms, women have been encouraged to come forward, and whether they felt that they have obtained justice, or conversely, whether the process itself has re-traumatized them and alienated potential witnesses. The core elements of this debate concern the concept of consent or lack thereof on the part of the women, and the extent to which women are subjected to the most intrusive questioning in order to establish the nature of the assault. Now, in the case of John Paul Akiesu, which I adjudicated in 1998, and of course, most of you are familiar with this case, it is the first time that we were called upon to produce jurisprudence on the question of rape constituting crime against humanity and genocide. And as I sat in that courtroom listening to witnesses, there was a woman who, witness J, who was testifying to about 19 gang rapes performed on her in the war situation. And the prosecutor kept asking her each time, well, excuse me, madam, I'm sorry to ask you this, but did he penetrate your vagina with his penis? Because there is no definition of rape in international law. And this prosecutor was relying on rape as he understood it in his national legal system, which is what we call the body part definition. It's not gender neutral. It's only what happens to women. And as you know, in the Yugoslav Tribunal, there was a great deal of evidence of the rape of young boys and men. And the woman then answered the prosecutor by saying, it's not just that was done to me. It's a sum total of everything they did to me. I'm a mother, these are young boys, and the things they said to me. Really drawing attention to her own dignity. And I and my two judicial colleagues paid attention to this voice of the victim. And that is why we created a definition of rape for international law for the first time. We said that rape is a physical invasion of a sexual nature committed in circumstances which are coercive. As I said, this was the first judgment on rape emanating from the ad hoc tribunals. And I framed my decision in this manner because, as I said, it was evident that in the circumstances that were being described, a conflict situation, there was no place whatsoever for the consideration of consent. I hope that this ruling would remove the age-old practice of focusing on the conduct of the woman victim in order to establish the guilt of the perpetrator. The decision was appealed, but not this portion dealing with the rape decision. And I was relieved about that. No one likes to be appealed or reversed. I felt that this was indicative of a more enlightened understanding of rape. I was wrong, since qualifications to the tribunal's initial decision were added later. It was, of course, followed in the ICTY, where they were able to extend that to circumstances that they were judging, and that is, as I said, the sexual violence perpetrated against boys. So this definition enabled them to apply it in a gender-neutral context. I'm also aware that 2 states here in the United States have changed their law to accommodate this definition. But as I said, I don't know where it's going now with the definition. The ICTY added the need for specific descriptions of the nature of the assault in the Furenzia case. So this could require the victim to reconstruct and painfully relive all phases of her rape, as well as furnish graphic descriptions of it. I will not go into the details of all the subsequent case law. This has been very well recorded by Kelly Askin, who is here and who's published volumes of books that analyzes the jurisprudence. Let me simply add that subsequent court definitions have allowed the possibility of raising consent in particular situations. They didn't overturn the concept of coercive circumstances, but they introduced troublesome qualifiers. The appeals court of the ICTR sitting in The Hague determined that the prosecutor has to still prove lack of consent. So he has to produce evidence of lack of consent, and of course he could rely on the coercive circumstances. So that's the troublesome feature, that it is now an element of the crime that the prosecutor has to prove lack of consent. In practice, this has meant looking at the crime through the gaze of the perpetrator, not that of the victim, as well as describing it in his terms and from his perspective. We must consider the impact that such an approach has on the willingness of women to come forward and testify. With its own description of the crime, the ICC has attempted to rebuild the firewall against admitting the element of consent. However, the ICC's definition has yet to meet the test of practical application. In the meantime, the cracks in the brick wall remain in evidence, as an expert meeting organized by OHCHR has determined. My own views on the matter of consent in the context of rape in warfare are grounded both in principle and in experience. So as I said, I will never forget the witnesses who came before the ICTR with harrowing accounts of atrocities. Despite the personal pain that reliving unspeakable abuse caused them, these individuals refused to remain silent or tacitly tolerant about violations of human rights. Their testimony helped to dismantle barriers to dialogue and to mend and restore the very foundations of peaceful coexistence, for it is the establishment of truth that fosters reconciliation. You must remember that the tribunals do not have powers of subpoena. You cannot compel a witness to testify. So all the witnesses, including these women, and of course men and women who witnessed the sexual violence, volunteered the testimony. And they said to us that they waited for this day to see justice being done. I want to now look at the elements of joint criminal enterprise and the duty of inquiry. Allow me to briefly illustrate how key legal concepts applied by the ad hoc international tribunals may have an impact on investigations. The first of such concepts is known as joint criminal enterprise, which has obvious application in cases of sexual violence. Like you, I learned my law under the common law system, and we know of conspiracy, aiding and abetting, collusion. So I had great resistance to this joint criminal enterprise, but it's in the ICC statute as well. I understand it comes from the civil system. This concept refers to any individual who plans, instigates, commits, orders, or abets the execution of crimes. It does not require the direct hand or the physical participation of the accused in the perpetration of the criminal act. Rather, it applies when this individual participates in criminal conduct with a plurality of actors. The case law of the tribunals has given us direction as to how to conduct investigations. We know that commanders have been found responsible for the incidental murders and rapes that were deemed to be the natural and foreseeable consequences of an ethnic cleansing campaign. Further, the tribunals have recognized that sexual violence should be a natural and foreseeable consequence of other wartime violations, rather than merely the outcome of the actions of errant soldiers whose abuses are not directly the responsibility of their commanders. The responsibility lies not just with the military leaders, but with their political masters as well. And of course, very interesting that the Dean announced that this would be the next lecture here, flowing from the Obama administration's appointment of the Attorney General to investigate Guantanamo and other events. And so once again, the question the media has been asking me is where the responsibility stops. I recall when I was lecturing to Indonesian Supreme Court judges once as well, they were really shocked that the notion of liability can extend to the head of state. So they felt got to be cut off somewhere. Just a few days ago, I said to a journalist that it includes everybody. It includes medical people, the lawyers who advised, and the interrogators, and those who gave the orders, and those who devised the policy. So now this brings me to the concept of the duty of inquiry, which lies with anyone in a superior position, military or civilian, who knew or had reason to know that crimes were being perpetrated or about to be committed and failed to take necessary and reasonable measures to prevent them and to punish those responsible. So there you are. You have interesting themes about a commander having the responsibility to predict that a crime may be a foreseeable consequence of his orders, and having the responsibility to take action to prevent and to punish. Let me reiterate and summarize the key elements of the cases from the tribunals. To begin with, international justice has now deemed rape as a natural and foreseeable consequence of a lack of discipline in cases involving other violations of international humanitarian law. Further, it has established command responsibility and upheld the duty of inquiry to reflect the obligation of persons in a position of responsibility and authority to prevent violations from occurring and to punish perpetrators when such crimes are committed. In addition, it considered that culpability could involve all those engaged in sexual violence crimes directly or indirectly. Now, I submit to you that the need to examine consent is at odds with coercive situations, particularly in wartime. Imagine the events that led to these and similarly grounded judgments as they actually took place in real life and as they are occurring right now as we speak in places like the Democratic Republic of Congo, Somalia, Afghanistan, and so on. So while in theory it may be intimidating to place this responsibility on superior officers, on the ground, when thousands and thousands of women and girls are being sexually violated by other civilians and by soldiers, we have to see that that's the context in which I speak. Picture the school where women were held with unrestrained soldiers, the prison camp guarded by drunken, ill-disciplined troops, the compound surrounded by Hutus where terrified Tutsi women had sought refuge and protection. Now, in such a compound, it was the mayoral buildings, the mayoral premises. Akayesu, this accused I mentioned, was the mayor. He himself did not kill anyone. He did not wield a weapon. He did not rape anyone. But we found evidence that he facilitated, encouraged, and enabled his Hutu militia, or the Hutu militia, to commit these rapes. He said things like, and this is 8 years ago, I still recall the evidence like I'm hearing it now, and the evidence was, he said to the Interamur killers, well, now you have the opportunity, and don't tell me tomorrow that you don't know what a Tutsi woman tastes like, because tomorrow they'll all be dead. So that it's on the basis of that kind of evidence that we found him guilty of rape constituting genocide, even though he did not perpetrate the rape. He was not a military officer, he was a civilian leader. Place these situations in their very real context of ethnic cleansing and genocide, and then ask yourselves if consent could have anything to do or have any meaning at all in such circumstances. I move on to analogies and contiguity. With its landmark resolution 1325 of 2000, the Security Council of the United Nations recognized that there is a fundamental difference in the way in which men and women experience conflict. Further, it reminded the international community of its obligations and responsibility under international human rights treaties and international humanitarian law, including the Geneva Conventions. It instructed all UN member states to uphold human rights and non-discriminatory principles when these are violated. States are engaged in conflict, peacemaking, and peace maintenance. Crucially, the resolution asserted the vital role that women play or must be called to play in putting an end to conflict, including peace negotiations, as well as in post-conflict reconstruction. In my current capacity as High Commissioner, I keep a very careful eye on violations allegedly committed by our own UN peacemakers on the ground. You may have heard of reports of UN peacekeeping soldiers being incriminated in the sexual abuse of children in Cote d'Ivoire. So building on these premises and closing a gap in the Security Council's action, Resolution 1820 of 2008 affirms that sexual violence against women is a tactic of war and thus a security issue of literally vital concern. As such, it demands commensurate responses. I am greatly encouraged by this development, since I believe that both in situations of war and of peace, sexual violence must be examined and judged by fully taking into account the victim's perspective and experience. This resolution of the Security Council 1820 of 2008 is historic because it's the very first time that the Security Council examined and passed a resolution on sexual violence. And it's also a change in the Security Council's own approach to be addressing thematic human rights issues. I was at a retreat, I come straight from there, from Innsbruck in Austria, and the Secretary General was there, and he announced that following this resolution, he's going to establish the position of a Secretary General Special Representative on sexual violence against women. So that is a new follow-up to this. But in order to translate victims' perspectives better, we can draw from other legal regimes which have established norms relevant to our discussion by way of contiguity or analogy. From this perspective, I wish to posit that human rights law and its cardinal principles of non-discrimination help to bolster the application of criminal law and international human rights law in cases of sexual violence, among others. Indeed, a comparative analysis of human rights standards at the regional level is indicative of the trajectory of international law concerning rape. And of particular interest here is, for example, the case of MC versus Bulgaria, heard by the European Court of Human Rights, a case concerning the rape of a young girl. I will not go into the details of this case, but merely address why I consider it significant. In formulating their decision, the European judges took into account jurisprudence from the international ad hoc tribunals in relation to coercive circumstances. While raising the issue of consent, the court went on to state that law and practice must reflect the changing social attitudes requiring respect for the individual's sexual autonomy and equality. It is hard to see how this interpretation could be faulted. Women are not necessarily walking around in a permanent state of sexual availability. In Africa, another interesting development, 11 heads of state signed the 2006 Pact on Security, Stability, and Development in the Great Lakes region, in which similar conclusions were reached. It was determined that the anti-rape legislation in all these African countries had been drafted from the male perspective, and that such an approach could hardly account for for women's experience. To correct this inequity, the 2006 agreement provided a new definition. It stated that sexual violence occurs if a person, quote, with intent, knowledge, recklessness, or negligence violates the sexual autonomy and bodily integrity of any woman or child. An interesting observation about this decision of the 11 heads of state in Africa and the Security Council resolution that I mentioned is how member states are now placing sexual violence against women in the context of their security agenda. In sum, then, the law at different latitudes and under different circumstances is moving forward to encompass the perspective and experience of the victims of sexual violence. At times, this movement has produced an encouraging cross-fertilization of legal approaches, which hopefully will benefit victims everywhere. And something that occurs to me is I do understand the sensitivity about the use of the word victims, because they are survivors, really. But that's the word that's used in the Rome Statute for the International Criminal Court. And we do need that term to refer to this particular vulnerable group. So, dear colleagues, let me now turn to elements that are relevant to the context of investigations of sexual violence. I have heard so much about the way investigations are conducted. When the prosecutions in the ad hoc tribunals first started, then the prosecutors said to me that the women are not prepared to talk about it. Well, naturally, you employ white males from foreign countries, driving up to them in white UN vehicles. We can well understand the reluctance of the women who are still traumatized and where the perpetrators are all around them from speaking. And therefore, I thought I should focus a little on investigations. So in this regard, international agreements, particularly the United Nations Convention on Transnational Organized Crime and its protocol to prevent, suppress, and punish trafficking in persons, especially women and children, are of particular interest. The underlying rationale of the anti-trafficking protocol is that an individual cannot freely consent to be trafficked. Indeed, when the elements of the crime of trafficking have been established, the consent of the individual is irrelevant. Similarly, the consent of the individual is irrelevant for torture under the Torture Convention, and this analogy we drew in our judgment. Intelligence-based and solid police work can trace the trafficking chain from the beginning to the end. Effective investigative methodology can probe the conditions of work and the level or absence of remuneration as indicators of labor exploitation. It follows that technically it is entirely possible to investigate and prosecute trafficking without the need for a victim to actually testify. Therefore, a good prosecutor should be able to argue a case without individual testimony by establishing the planning, the modus, and the effects of the crime. And I submit to you that the application of this approach to investigations of rape in armed conflict could also yield optimal results. I also recall that we have delivered many convictions of genocide and crimes against humanity in the Rwandan context without forensic evidence or district surgeon's evidence of a body. So no body or no corpse was produced to us. Let me reiterate that sexual violence is almost invariably the foreseeable consequence in situations of conflict and in a climate that fosters mass atrocities. In reconstructing the entire chain of responsibility and authority, we must hold accountable all the perpetrators and their political and military enablers. In this perspective, we must do a better job of ensuring that victims of sexual violence obtain full and real justice. To this end, we should never lose sight of the fact that countries experiencing conflict or recovering from war often have weak institutions. An originally patchy or damaged judicial and police infrastructure often makes the system unwilling or unable to address cases of sexual violence. As a result, impunity is the rule rather than the exception. Impunity is also compounded by the fact that often victims of sexual violence cannot find and identify perpetrators. Thus, they are left with no judicial recourse. This can affect a large group, and this is in fact the situation in the DRC right now. Indeed, the majority of victims of sexual violence in armed conflict cannot either seek or obtain justice. Allow me to take this opportunity to draw your attention to an OHCHR pilot project currently under development. This initiative involves an assessment in the Democratic Republic of Congo of alternative ways in which, beyond the formal justice mechanisms, reparation and other remedies could be made accessible to victims of sexual violence. The idea is to empower them by shifting the stigmatization of sexual violence from the victim to the perpetrator, and by providing or facilitating access to assistance. Moreover, we will explore how to create a public and or a quasi-judicial forum for victims that will recognize the harm that has been done to them with the view to ensure the effective implementation to their right to remedy and reparation. And these are all very interesting jurisprudence, which I'm sure you will be following as the work of the ICC unfolds, because a very large part of that statute spells out the expectations of reparation for victims. Ultimately, whether through formal justice system or through alternative means, we always need to pose the right questions to the right people. We need to devise procedures that are truly protective and supportive of the victims. We need to frame sexual violence from their perspective, and above all, we must strive for an outcome that does not re-traumatize the victims in their quest for justice. That concludes my address, but I just want to briefly note how important the developments just in the last 15 years has been, because since Nuremberg, for over 60 years, we had no mechanism to bring these perpetrators of serious crimes to justice. And finally, we have it when the Security Council set up these two ad hoc tribunals, and other courts followed. And even as I look back, I see how much has happened just in the past 15 years. And here I do want to pay tribute to Professor Henry King. I just heard that, of course, he comes from this university, and I am really sorry that we have not now lost him, but it's people like him who did the pioneering work for us in Nuremberg. And so thank you very much for your attention.
For Q&A, and I'm sure everybody's really excited to jump in. Can I go ahead and take the liberty as host of asking the first question, and it's one that you and I were talking about before this session started when we were walking around the Botanical Garden, and that's basically this question. Next week we have Mary Robinson coming to the university to speak and deliver the Inamori lecture and get the Inamori Prize. There's been some controversy about it. And what we were talking about is sort of what the lessons your office and you personally learned from her experience at Durban 1, which you put into play in Durban 2, and what sort of the challenges are of being the High Commissioner for Human Rights in the UN system. Would you address that?
Well, firstly, I congratulate you in securing Mary's attendance here for a lecture. during a press conference during the Durban Review Conference. We don't call it Durban 2, by the way. It's, you know, a certain lobby calls it Durban 2 because they think it's no different to Durban 1. So the press said, why am I taking on this? Am I not afraid that, you know, are you not afraid that your reputation will be damaged, as was Mary Robinson's? And I said, we consider her a hero, and that she did an excellent job with the Durban conference. I think that, with hindsight, we learned lessons, and so I had the benefit of that because of her experience. I also have an extremely experienced and expert staff who advise me every step of the way. Now, Mary Robinson and I hold the position of Secretary General to that conference, and that's what she was. She was the Secretary General. She was not the chair of that conference. The chair at the Durban conference was the South African Foreign Minister. The chair of the review conference was the Attorney General and Minister of Kenya. But the Secretary General was on the podium, and so was I during the Durban Review Conference when President Ahmadinejad made his address, and there was pandemonium because there were protests from Israeli students who wore clown outfits and noses, red noses, and threw it at them. And the Secretary General personally tried to intervene to stop that level of audience disruption, and he took the hammer himself, and nobody paid attention. I noted that there were two camps anyway. There were the Israeli students and there were Iranian students clapping regularly to drown out any other sounds. So the thing is, I learned to deal with it outside the hall, and I did sign the order then for the removal of these students. That was one way of dealing with it. But long before, I started. Mind you, it's an anniversary. I started on the 1st September last year, so I'm very new. I shouldn't be giving advice to the types of Mary Robinson. She has far more experience than me. But at least we were able to anticipate, and we dealt with it in informal sessions with conversations. I never thought I had any diplomatic skills, but you find them when you need them. I think it's a huge challenge when there are such intractable differences and different points of view sometimes. And that's where Mary found herself. She had undercurrents of opposition, and some of it coming from the United States because they did not want the slavery and the reparation issue to come up. And then she faced this Arab element, shall I say, and I know that it was extremely shocking, extremely hurtful, their kind of propaganda which went on in the NGO forum mainly, but some of it spilt over in the main forum. Yeah, so what did I do? I said no NGO forum. So I was able to do that because I saw what her experience was. But as I said, it's a challenge, and you know, I admire the way she handled it. I think she's done us all a huge service, because if you look at the document that emerged from the Durban conference 8 years ago, it's a very good document. The outcome document that emerged from the review conference is also a good document. It reaffirms the original document. And I am more and more dedicated to see things under the umbrella of discrimination and violation of equality principle. And when you take discrimination, you can deal with the issue of, say, sexual orientation, which is another issue that quite a few states do not want the High Commissioner to venture into. And then issues such as the recent outburst in China, where you might see evidence of religious and racial intolerance. So the umbrella of discrimination to me is very important, and I really urge you to look at the outcome document. You have any ideas, you tell me. I'm only 1 year old.
Other questions?
I have a question. I'm a member of the NGO Committee on Aging at UN headquarters in New York. We have been advocating for a convention on the rights of older persons. And made some progress at the Commission on Social Development this last February. I'm wondering if you have a position on the promotion of that convention, what your position is.
Very much so. You know, I'm one of the. I would be one of the beneficiaries anyway.
I would too.
Well, like you, it's just strange to me that it has never been done before, and we're working very seriously on it, and I expect to see a convention. At least they're taken very seriously. Some of these initiatives have taken a very long time, such as the International Criminal Court, which took almost 50 years. Some, not even the Convention for Indigenous Peoples, took very long. And I think that we can work fast on this modern age. And I've seen some drafts, and I've talked with people who are working on the issues. I wish you well on that, and I assure you of my support. And you, Nick?
Yes, do you consider the genital mutilation of women to be a crime of violence against women? And if so, what role, if any, do you see for justifications grounded in religious faith?
My office is actively encouraging states to pass legislation criminalizing the practice. So you could see that this argument of it being a cultural or religious practice has no weight and is being raised less and less by people. I know that there are other initiatives that think that legislation is so intrusive, they should rather educate the cutters, find them some other jobs, because this is a way of earning a means of living. But I have been involved in the issue of long before I played a role in the international sphere. And I was present in Eritrea when, I was in the women's movement, and we got the head of the Christian church and the Islamic priest to speak on television, and both said it's against their religion. So I think that the people are realizing that rather than it being a sin not to be cut, it's rather a sin to be cutting people. So thank you for raising that question. You have to organize. Yes.
It's a follow-up. It's about.
All right.
You talked about the importance of consent, and if I understand correctly, in Afghanistan there was an adoption of the principle that a woman can consent by a woman is not relevant in marriage, and this publicity that was given to the concept that sexual favors are a duty of the wife. Where does that fit in terms of international justice?
It conflicts with the principle of equality, dignity of the individual. It contravenes all the fundamental principles set out in the Universal Declaration of Human Rights. I have written formally objecting to that legislation. Some changes have been made, but you're quite right, that provision is still there, an obligation to provide sexual services. If not, he could withdraw maintenance of the spouse. And we raised that part again via a letter. Some people said to me, it's during the elections, please don't raise this now. Raise it later, because the people standing for election need the fundamental leaders on their side. So again and again, the rights of women are sacrificed for expediency and for political reasons. I'll continue to address that matter.
We have time for 2 more questions. How about this gentleman here?
What is your view of children soldiers, and how do you prosecute, or what responsibility do you hold them to?
Firstly, the Rome Statute of the ICC does not prosecute anyone under the age of 18. So if there were child soldiers involved, they perpetrated crimes, they don't come under international court, nor does the Sierra Leone court, which is the court that delivered the very first decision on the recruitment of child soldiers. It's a war crime, and it's a crime against humanity, and that's the first charges in the first trial before the ICC, where Lubanga Diallo is charged for recruiting children. So why I'm mentioning this is, well, it's a prosecutor's decision. Obviously, he only found evidence of that, and that's what's being charged there. It occurs all over. I recently had to bring it up in Somalia, recruitment of children there as well.
Okay, last question. How about you?
Prosecuting sexual assault and war crimes is, of course, tantamount to the battle against that sort of crime, but at some point there's some sort of national acceptance of that sort of behavior. So I was wondering, what would you hope or like to see governments do to stop that sort of behavior nationally and condemn it nationally? What would you see as the most effective route to take to balance out the international condemnation?
Well, I come from South Africa, and I'm also very concerned about what role models we have and what examples are set. My niece teaches at university, and when she opened up the class discussion, the opinion of the young men in her class was, what's wrong with rape? What's wrong with having a number of wives? So I would say there's a responsibility on leaders to be proper role models. Too much of adultery is being a big acceptable behavior on the part of leaders and all over the world, not just in the South. Now, what kind of remedies? Police have to be trained to take the matter seriously and to prosecute if that's what the women want. Women should be part of the decision-making process and should be involved in what kind of measures and policies they want to see in place. I would like to see more reparation and help to the women to rebuild their lives. We're talking about almost 1 million women in the DRC, and it's even happening right now. So the UN soldiers provide shelter during the night from these women because everybody knows it's going around them all the time. The Secretary General said to Mr. Kabila that that is totally unacceptable. So from the outside, we can only raise the voices. Inside, I think that we need to educate. We need education at schools so proper values are put in place to value every human being, men and women. And I think that it is achievable. I mean, if the United States managed to stop the whole world from smoking, and you're also really instrumental in playing a tremendous role in your civil society movements to help to bring apartheid down. I never thought it will end in my lifetime. So everything is possible. If civil society takes charge. We've trusted in governments too long, I think. So let's look to ourselves now. Thank you.
Well, Judge Pillay, Shannon French mentioned a number of historic firsts. Here is another one. We've been giving this award out now for 6 years, and I don't know, it's long overdue, but you're the first woman to receive the award. And it's shocking, but it's a wonderful opportunity for us. Thank you for the wonderful lecture, for coming here to Cleveland. She flew all the way from Innsbruck. She can only be here for a few hours. She has to go back to meet at the United Nations tomorrow. And it's very hard, I know, for someone with your busy schedule to come and do something for this, and we're very appreciative. And I hope that you will display this and remember us when you look at it. Thank you very much. And Judge Pillay, before she runs off to get her airplane at 2 o'clock, she's agreed to stick around for an hour with us. There's a reception with food for everybody across the hall in rooms A66 and A67. We hope you will join us and have a chance to talk one-on-one with the High Commissioner. Thank you.